Let's start by reviewing the forms of property ownership. Which of the following is considered real property under most state real estate laws? Is it A, a refrigerator that can be unplugged and moved? B, a built-in fireplace in a home? C, a tenant's removable window air conditioner? Or D, a stack of firewood in the backyard? The correct answer is B, a built-in fireplace in a home. Real property includes land and anything permanently attached to it, such as buildings or fixtures. Personal property refers to movable items not permanently affixed to the land. Which statement about the distinction between real property and personal property is not accurate? Is it A, real property includes land and anything permanently attached to it? B, personal property can become real property if it is permanently affixed? C, fixtures are always considered personal property regardless of attachment? Or D, the intent of the parties can influence whether an item is real or personal property? The correct answer is C. Fixtures are always considered personal property, regardless of attachment. Why this can be tricky? The distinction often depends on attachment and intent. The incorrect statement confuses the definition of fixtures, which are generally considered real property, not personal property. If a seller removes a chandelier from a home before closing, which of the following is most likely true under standard real estate law? Is it A, the seller may be in breach of contract unless the chandelier was excluded in writing? B, the seller is always allowed to remove any lighting fixture before closing? C, the buyer must pay extra for the chandelier if they want it left behind? Or D, the chandelier is personal property and can be removed at any time? The correct answer is A, the seller may be in breach of contract unless the chandelier was excluded in writing. Why this is tricky? Chandeliers are typically considered fixtures and thus real property. Removing one without agreement may violate the sales contract unless specifically excluded. Maria buys a house and discovers the previous owner took the custom-built bookshelves that were attached to the living room wall. Based on property law, what is the likely classification of these bookshelves? Is it A, they are personal property and removal is allowed? B, they are trade fixtures and must be removed by the seller? C, they are real property and should have remained with the house? Or D, they are emblements and belong to the previous owner? The correct answer is C, they are real property and should have remained with the house. Custom-built, attached bookshelves are generally considered fixtures, making them real property that should remain with the house unless excluded in the sale agreement. A landlord installs a new dishwasher in a rental unit. When the tenant moves out, who typically owns the dishwasher under most state laws? Is it A, the tenant owns the dishwasher and may remove it? B, the landlord owns the dishwasher and it stays with the property? C, ownership depends on the value of the dishwasher? Or D, the dishwasher is considered personal property and can be removed by either party? The correct answer is B. The landlord owns the dishwasher and it stays with the property. A dishwasher installed by the landlord becomes a fixture and is considered part of the real property, so it remains with the property after the tenant leaves.
How'd you do on the first 5 questions? Go ahead and subscribe to Birdsey now and turn your progress into exam day confidence. Ready to jump back in? Let's go.
Freehold estates terminology and characteristics. Which characteristic is essential to a fee simple absolute estate? Is it A, it is of unlimited duration? B, it automatically reverts to the grantor upon death? C, it must be used for a specific purpose? Or D, it cannot be inherited by heirs? The correct answer is A, It is of unlimited duration. A fee simple absolute estate is the highest form of ownership, providing the owner with complete control, unlimited duration, and the right to transfer the property. It is not subject to any conditions or limitations imposed by previous owners. Which of the following statements about a life estate is not accurate? Is it A, a life estate ends when the measuring life dies? B, the life tenant cannot will the property to heirs? C, a life estate is always created by will? Or D, a life estate may have a remainderman? The correct answer is C. A life estate is always created by will. Why this is tricky? The phrasing asks for the exception, and all but one statement are true. Life estates end at the death of the measuring life, cannot be willed by the life tenant, and may have remaindermen, but they are not always created by will. Which freehold estate type is least likely to include automatic reversion to the original owner if a condition is violated? Is it A, fee simple determinable? B, fee simple absolute? C, fee simple subject to condition subsequent? Or D, fee simple defeasible? The correct answer is B, fee simple absolute. Why this can be tricky? The question asks for the least likely, and many confuse fee simple determinable with fee simple subject to condition subsequent. Fee simple absolute does not include any conditions or automatic reversion. Maria grants her brother a property to use for his lifetime, after which it will pass to her niece. What type of interest does the niece hold? Is it A, life estate? B, fee simple absolute? C, reversionary interest? Or D, remainder interest? The correct answer is D, remainder interest. The niece holds a remainder interest because she will receive the property after the life estate ends. This is a key characteristic of remainder interests in freehold estates, as opposed to reversionary interests. A developer conveys land to a city as long as it is used for a park. But as it stops being a park, the land returns to the developer. What type of estate does the city hold? Is it A, life estate? B, fee simple absolute? C, fee simple determinable? Or D, fee simple subject to condition subsequent? The correct answer is C, fee simple determinable. The city holds a fee simple determinable estate, which automatically ends and reverts to the grantor if the specified condition is violated. This is a common form of defeasible fee estate in property law.
If you want more than just rapid-fire questions, head over to birdsey.ai. You can take unlimited practice exams and get instant help from your personal AI study partner. It's like having a tutor 24/7. Try it free. You'll find a link in the description.
Which term describes a freehold estate that provides the greatest possible ownership rights in real property? Is it A, life estate? B, fee simple determinable? C, fee simple absolute? Or D, estate for years? The correct answer is C, fee simple absolute. A fee simple absolute estate is the highest form of freehold ownership, granting the owner full rights to possess, use, and transfer the property indefinitely, subject only to governmental powers such as taxation or eminent domain. Leasehold estates and tenancy classifications. Which type of leasehold estate automatically renews for successive periods unless proper notice is given to terminate? Is it A, periodic tenancy? B, estate at will? C, estate for years? Or D, tenancy at sufferance? The correct answer is A, periodic tenancy. An estate from period to period, also known as a periodic tenancy, automatically renews unless either party gives notice to terminate. This is a common form of leasehold estate for residential and commercial leases. Which of the following is not a characteristic of joint tenancy? Is it A, right of survivorship, B, unity of possession, C, ability to will the property to heirs, or D, unity of interest? The correct answer is C, ability to will the property to heirs. Why this can be tricky. Joint tenancy requires unity of time, title, interest, and possession, and includes the right of survivorship. The ability to will the property is not a feature of joint tenancy. That applies to tenancy in common. Maria signs a lease for an apartment that runs from June 1st to August 31st, with no mention of renewal. What type of leasehold estate does Maria have? Is it A, periodic tenancy, B, estate for years, C, estate at will, or D, tenancy at sufferance? The correct answer is B, estate for years. Maria has an estate for years, which is a leasehold estate with a definite start and end date. It does not automatically renew and ends without notice at the expiration date. A tenancy at sufferance gives the tenant which of the following rights? Is it A, the right to renew the lease automatically, B, the right to sublet the property, C, the right to remain indefinitely with landlord consent, or D, no legal right to occupy the property? The correct answer is D, no legal right to occupy the property. Why this is tricky. Tenancy at sufferance does not grant the tenant any legal right to remain. The tenant is essentially a holdover and may be evicted. The other options describe rights not associated with this tenancy. After Sam and Lee purchase a property together, Sam dies and Lee automatically becomes the sole owner. What form of ownership did they hold? Is it A, tenancy in common, B, tenancy by the entirety, C, joint tenancy, or D, community property? The correct answer is C, joint tenancy. They held joint tenancy, which includes the right of survivorship. When one joint tenant dies, the surviving tenant automatically acquires full ownership of the property. Joint tenancy, tenancy in common, and community property. Which form of property ownership allows each co-owner to pass their interest to heirs rather than the other owners if they die? Is it A, joint tenancy, B, tenancy in common, C, community property? Or D, sole ownership? The correct answer is B, tenancy in common. In tenancy in common, each owner's share can be passed to their heirs upon death, rather than automatically transferring to the surviving co-owners as in joint tenancy. Which statement about community property is always true in every state where it is recognized? Is it A, all property owned before marriage becomes community property after marriage, B, only the spouse who earned the income owns the property, C, property acquired during marriage is generally considered community property, or D, community property can only be held as joint tenancy? The correct answer is C, property acquired during marriage is generally considered community property. Why this can be tricky. Community property laws vary by state, but the defining feature is that property acquired during marriage is owned equally by both spouses. Not all other statements are universally true. If 4 people own property as joint tenants and one sells their share, which of the following best describes the resulting ownership structure? Is it A, all 4 owners become tenants in common, B, the property automatically becomes community property, C, the remaining 3 owners become tenants in common with each other, or D, the new owner is a tenant in common and the other 3 remain joint tenants. The correct answer is D. The new owner is a tenant in common, and the other 3 remain joint tenants. Why this is tricky. When a joint tenant sells their share, the new owner becomes a tenant in common with the remaining joint tenants who still hold their shares as joint tenancy among themselves. Maria and Louise, a married couple in a community property state, buy a house together during their marriage. What is the default form of ownership for this property? Is it A, community property, B, joint tenancy, C, tenancy in common, or D, sole ownership? The correct answer is A, community property. In community property states, property acquired by a married couple during marriage is presumed to be community property unless otherwise agreed. 2 friends, Sam and Jordan, purchase a property as tenants in common. If Sam dies, who receives Sam's share of the property? Is it A, Jordan automatically receives Sam's share, B, Sam's heirs or beneficiaries receive Sam's share, C, the property reverts to the state, or D, the share is divided equally among all remaining property owners? The correct answer is B, Sam's heirs or beneficiaries receive Sam's share. In tenancy in common, Sam's share passes according to Sam's will or state law, not automatically to Jordan. Life estates and remainder interests. What is the primary difference between a life estate and a fee simple absolute ownership? Is it A, a life estate ends at the death of the measuring life, while fee simple absolute does not? B, a life estate allows the owner to sell the property outright. C, fee simple absolute cannot be inherited. Or D, a life estate always reverts to the original owner. The correct answer is A, a life estate ends at the death of the measuring life, while fee simple absolute does not. A life estate grants ownership for the duration of a person's life, while fee simple absolute is the most complete form of ownership, lasting indefinitely and inheritable by heirs. Which statement about a remainderman in a life estate is not accurate? Is it A, the remainderman receives the property after the life tenant's death? B, the remainderman holds a future interest during the life tenant's lifetime? C, the remainderman has the right to occupy the property during the life tenant's lifetime? Or D, the remainderman's interest can be transferred to another party before the life tenant dies? The correct answer is C. The remainderman has the right to occupy the property during the life tenant's lifetime. Why this can be tricky. The remainderman does not have any possessory rights until the life estate ends, but they do have a future interest, not a present one. Maria grants her house to her brother for his lifetime, and then to her niece. Who holds the remainder interest in this arrangement? Is it A, Maria, B, Maria's niece, C, Maria's brother, or D, the state? The correct answer is B, Maria's niece. Maria's niece holds the remainder interest, as she will receive ownership after her brother's life estate ends. The brother is the life tenant, and Maria's niece is the remainderman. If a life tenant, Tom, sells his interest in a property to Alice, what happens to Alice's rights when Tom dies? Is it A, Alice becomes the new life tenant for her own lifetime? B, Alice inherits the property in fee simple? C, Alice's rights to the property end when Tom dies? Or D, Alice and the remainderman share ownership after Tom's death? The correct answer is C. Alice's rights to the property end when Tom dies. Alice's rights end when Tom dies because she only acquires the life estate measured by Tom's life, not her own. The property then passes to the remainderman. Land use controls and limitations. Government powers affecting real estate ownership. Which government power allows the state to take private property for public use with just compensation? Is it A, eminent domain, B, police power, C, Escheat, or D, taxation? The correct answer is A, eminent domain. The power to take private property for public use with compensation is called eminent domain. This is one of the 4 primary government powers affecting real estate ownership, along with taxation, police power, and escheat. Which of the following is not an example of police power affecting real estate ownership? Is it A, zoning ordinances, B, building codes, C, eminent domain, or D, environmental regulations? The correct answer is C, eminent domain. Why this is tricky? All options may seem related to government authority, but only zoning, building codes, and environmental regulations are police powers. The power of eminent domain is separate and involves taking property, not regulating its use. A property owner dies without a will and no identifiable heirs. Which government power allows the state to claim ownership of the property? Is it A, taxation, B, escheat, C, police power, or D, eminent domain? The correct answer is B, escheat. Why this can be tricky? The scenario may sound like eminent domain, but escheat is the correct power when there are no heirs or will. Eminent domain is for public use, not unclaimed estates. Maria wants to build a second story on her home, but the city denies her permit because her plan exceeds local height restrictions. Which government power is the city exercising in this decision? Is it A, eminent domain, B, escheat, C, police power, or D, taxation? The correct answer is C, police power. The city is using its police power to enforce zoning laws and protect public welfare. Police power allows local governments to regulate land use, including building height, to ensure community standards are met. A city plans to widen a road and offers compensation to homeowners whose land will be used for the project. What legal principle requires the city to pay these owners? Is it A, police power, B, Escheat, C, taxation, or D, eminent domain? The correct answer is D, eminent domain. The city must pay just compensation under the principle of eminent domain. This government power ensures property owners are compensated when their land is taken for public use, such as road expansion. A city council passes a new ordinance requiring all homeowners in a certain district to maintain a minimum amount of green space on their property. If a homeowner wants to pave over their entire yard for parking, which government power allows the city to enforce this restriction? Is it A, eminent domain, B, taxation, C, police power, or D, escheat? The correct answer is C, police power. This scenario describes the city's use of police power, which allows local governments to regulate land use for the health, safety, and welfare of the public, including zoning and environmental requirements. Zoning classifications and permitted uses. Which zoning classification is typically used to designate areas for single-family homes? Is it A, residential, B, commercial, C, industrial, or D, agricultural? The correct answer is A, residential. Residential zoning is most commonly used to designate areas for single-family homes, as defined by local zoning ordinances. This classification restricts land use to residential dwellings and often excludes commercial or industrial activities. Which of the following is least likely to be permitted in a property zoned for light industrial use? Is it A, small-scale warehousing? B, office space for logistics companies? C, single-family residence? Or D, assembly of electronic components? The correct answer is C, single-family residence. Why this can be tricky. Light industrial zones may allow some commercial or office uses, but residential uses are generally not permitted. The other options could be allowed depending on local ordinances. A developer wants to build a shopping center in an area currently zoned for agricultural use. What must the developer typically do before construction can begin? Is it A, begin construction immediately? B, request a zoning change from the local authority? C, apply for a building permit only? Or D, notify neighboring property owners only? The correct answer is B, request a zoning change from the local authority. The developer must usually apply for a zoning change or variance to allow commercial use, since agricultural zoning does not permit shopping centers or similar developments. If a property is located in a mixed-use zone, which statement is most accurate about its permitted uses? Is it A, only residential uses are allowed? B, only commercial uses are allowed? C, all types of land use are allowed without restriction? Or D, both residential and commercial uses are generally allowed? The correct answer is D, both residential and commercial uses are generally allowed. Why this is tricky. Mixed-use zones allow a combination of uses, but not all possible uses. The correct answer recognizes that both residential and commercial uses are typically allowed, but not necessarily every type of use. Maria owns a property zoned for commercial use and wants to open a small factory. What zoning issue might she encounter? Is it A, she can open the factory without restrictions? B, she may be prohibited from manufacturing due to zoning restrictions? C, she must apply for a residential permit? Or D, she can only operate retail businesses on the property? The correct answer is B, she may be prohibited from manufacturing due to zoning restrictions. Commercial zoning usually does not permit industrial or manufacturing activities, so Maria may need to seek a zoning change or variance to operate a factory on her property. Deed restrictions and private land use controls. What is the primary purpose of a deed restriction in private land use control? Is it A, to limit how the property can be used? B, to determine property tax rates? C, to establish property boundaries? Or D, to enforce building codes? The correct answer is A, to limit how the property can be used. Deed restrictions are used to limit or control the use of property by future owners, ensuring that certain standards or uses are maintained in a community or development. Which of the following is least likely to be enforceable as a private deed restriction? Is it A, limiting the height of fences? B, prohibiting commercial activities? C, restricting ownership based on religion? Or D, requiring architectural approval for additions? The correct answer is C, restricting ownership based on religion. Why this can be tricky. Some restrictions may seem valid, but are unenforceable if they violate public policy or fair housing laws, such as those based on race or religion. A homeowner in a subdivision wants to build a shed, but the deed restriction prohibits structures taller than 10 feet. What is the likely outcome if the shed is 12 feet tall? Is it A, the city will issue a fine for the violation? B, the homeowner may be forced to lower or remove the shed? C, the restriction is automatically voided after construction? Or D, the shed is allowed if neighbors approve? The correct answer is B, the homeowner may be forced to lower or remove the shed. The homeowner would likely be required to remove or modify the shed to comply with the deed restriction, as private controls are enforceable by the homeowners association or neighbors. If a deed restriction conflicts with a local zoning ordinance, which typically prevails? Is it A, the deed restriction always prevails? B, the zoning ordinance always prevails? C, neither applies if they conflict? Or D, the more restrictive rule prevails? The correct answer is D, the more restrictive rule prevails. Why this is tricky: many assume government rules always override, but the more restrictive rule, whether public or private, usually controls land use. Maria buys a home in a community with a deed restriction requiring all homes to have brick exteriors, but she wants to use wood siding. What is the likely result if she proceeds? Is it A, she can use wood siding if she gets a building permit? B, the restriction is unenforceable after purchase? C, she may be required to replace the wood siding with brick? Or D, she can ignore the restriction if no one complains? The correct answer is C, she may be required to replace the wood siding with brick. Maria will likely face legal action from the homeowners association or neighbors to enforce the deed restriction, requiring her to replace the siding with brick.
Have you noticed the code in the bottom corner? The next time you're stumped, take that code to birdsey.ai. You'll get immediate help, complimentary study sessions, and access to hundreds of additional questions. It's the best tool to help you pass with confidence.
Easements and licenses, definitions and types. What is the primary difference between an easement and a license in real estate law? Is it A, an easement is a permanent right, while a license is temporary? B, a license is recorded with the deed, but an easement is not? C, both easements and licenses are always transferable to new owners? Or D, a license grants ownership, while an easement does not? The correct answer is A. An easement is a permanent right, while a license is temporary. An easement is a legal right to use another person's land for a specific purpose, which typically runs with the land, while a license is a temporary, revocable permission to do something on another's land. Which of the following statements about easements is not generally true? Is it A, easements may be created by express agreement? B, easements can be appurtenant or engross? C, easements are always revocable at the will of the landowner? Or D, easements may be terminated by merger of the properties? The correct answer is C. Easements are always revocable at the will of the landowner. Why this is tricky? The distractors are all true for most easements, but the correct answer describes a feature of licenses, not easements. Easements are typically not revocable at will by the landowner. Maria owns a home with a driveway that crosses her neighbor's property, and the neighbor sells the property to someone else. Does Maria retain the right to use the driveway under an appurtenant easement? Is it A, no, the easement ends when the property is sold? B, yes, because the easement runs with the land? C, no, unless Maria pays a new fee to the new owner? Or D, yes, but only if the new owner agrees in writing? The correct answer is B, yes, because the easement runs with the land. An appurtenant easement attaches to the land and remains in effect even if the servient property is sold, so Maria retains her right to use the driveway. Which of the following best describes a license in the context of land use? Is it A, a permanent right to cross another's land for access? B, a recorded right that transfers with the property? C, a legal interest in land that cannot be revoked? Or D, a temporary, revocable permission to use land without creating an interest in it? The correct answer is D, a temporary, revocable permission to use land without creating an interest in it. Why this may be tricky. The options use similar language, but only one correctly emphasizes that a license is revocable and does not create an interest in land, distinguishing it from an easement. A restaurant owner receives written permission from a neighboring property owner to use their parking lot for weekend events, but the neighbor later sells the property. Can the restaurant owner continue to use the lot? Is it A, yes, because the permission was in writing? B, yes, if the restaurant owner pays a fee to the new owner? No, because licenses do not transfer to new owners. Or D, no, unless the original owner specified the license was permanent. The correct answer is C, no, because licenses do not transfer to new owners. A license, even if written, is generally personal and revocable, and does not transfer to new owners, so the restaurant owner cannot continue to use the lot without the new owner's consent. Encroachments and adverse possession concepts. What is the legal term for a structure that extends onto a neighboring property without permission? Is it A, encroachment, B, easement, C, lien, or D, license? The correct answer is A, encroachment. An encroachment is when a structure or improvement extends beyond the property line onto a neighboring property without permission. This can lead to disputes and may require legal action to resolve. Which of the following is not typically required to establish adverse possession? Is it A, open and notorious use, B, continuous possession for a statutory period, C, written permission from the owner, or D, hostile possession? The correct answer is C, written permission from the owner. Why this is tricky. All options except written permission from the owner are classic requirements for adverse possession. Written permission actually defeats adverse possession because the use must be without the owner's consent. If a neighbor's fence has been on your property for many years, but you never noticed, which element of adverse possession might be missing? Is it A, hostile possession, B, open and notorious use, C, continuous possession, or D, exclusive use? The correct answer is B, open and notorious use. Why this can be tricky. The fence may be hostile and continuous, but if you never noticed, the use may not be open and notorious, which is required for adverse possession. Maria builds a shed that accidentally extends 2 feet onto her neighbor's land, and the neighbor does not object for several years. What legal concept might allow Maria to eventually claim ownership of the encroached land? Is it A, easement by necessity, B, license, C, restrictive covenant, or D, adverse possession? The correct answer is D, adverse possession. Adverse possession may allow Maria to claim ownership if her use is open, notorious, continuous, hostile, and meets the statutory period, even if the encroachment was accidental and the neighbor did not object. Title and transfer of ownership. Methods of acquiring and transferring title. Which method of transferring title to real property is most commonly used in voluntary transactions? Is it A, deed, B, eminent domain, C, adverse possession, or D, foreclosure? The correct answer is A, deed. A deed is the most common instrument used to voluntarily transfer title to real property. It is executed by the grantor and delivered to the grantee to complete the transfer of ownership. Which of the following statements about title transfer by will is not correct? Is it A? A will is a legal document used to transfer title after death. B. The executor is responsible for carrying out the terms of the will. C. title transfers immediately to heirs upon the testator's death. Or D. Probate is the process that validates the will and oversees title transfer. The correct answer is C. Title transfers immediately to heirs upon the testator's death. Why this can be tricky. The statement about a will transferring title immediately upon death is incorrect. Title passes after probate, not instantly at death, which is a common misconception. Maria sells her home to David, and they sign a deed, but Maria never delivers the deed to David. Who holds legal title to the property in this situation? A. David. B. Both Maria and David. C. The state. Or D. Maria. The correct answer is D. Maria. Delivery of the deed is essential for title transfer. Without delivery, even if signed, legal title does not pass to the buyer, so Maria retains legal title.
If a person acquires title to land by adverse possession, which of the following is generally not required? Is it A. Open and notorious possession? B. Payment of property taxes?
C. Continuous possession for a statutory period? Or D. Hostile possession without the owner's permission? The correct answer is B. Payment of property taxes. Why this is tricky. Many assume payment of property taxes is always required, but some jurisdictions do not require it for adverse possession. Open, notorious, and continuous possession are generally required. After a foreclosure sale, the lender receives title to the property. What is the most accurate description of how the lender acquired title? Is it A. By voluntary transfer from the borrower? B. By inheritance? C. By involuntary transfer through foreclosure? Or D. By gift from the borrower? The correct answer is C. By involuntary transfer through foreclosure. In a foreclosure, the lender acquires title through an involuntary transfer as the property is taken due to the borrower's default and sold to satisfy the debt. Deed types and deed clauses. Which type of deed provides the greatest protection to the grantee regarding the title to the property? Is it A. General warranty deed? B. Special warranty deed? C. Quitclaim deed? Or D. Bargain and sale deed? The correct answer is A. General warranty deed. A general warranty deed offers the most comprehensive protection to the grantee because it guarantees the title against all claims, both those arising during and before the grantor's ownership. Which statement about a quitclaim deed is not accurate? Is it A. It conveys any interest the grantor may have? B. It provides no warranties of title? C. It guarantees the grantor owns the property? Or D. It is often used to clear up title issues? The correct answer is C. It guarantees the grantor owns the property. Why this can be tricky. Quitclaim deeds transfer whatever interest the grantor has, if any, but do not guarantee clear title or ownership. They do not warrant that the grantor owns the property or that the title is free of defects. Maria sells her home to David using a special warranty deed, and David later discovers a title defect from a previous owner. Who is responsible for this defect under the deed? Is it A. Maria is responsible for all title defects? B. David is protected against all prior defects? C. David is responsible for defects that occurred before Maria owned the property? Or D. The title insurance company is always responsible? The correct answer is C. David is responsible for defects that occurred before Maria owned the property. A special warranty deed only protects against defects that arose during the grantor's ownership, not before. Therefore, Maria is not responsible for defects from previous owners. Which clause in a deed states the grantor has the legal right to transfer the property? Is it A. Habendum clause, B. Covenant of Seisin, C. Granting clause, or D. Covenant of quiet enjoyment? The correct answer is B. Covenant of Seisin. Why this is tricky. The granting clause transfers the property, but the covenant of Seisin specifically assures the grantor has the right to convey. Many confuse the two, but only the covenant of Seisin addresses legal ownership and authority. After purchasing a property with a bargain and sale deed, Tom discovers an unpaid lien from before the seller's ownership. What protection does Tom have under this deed? Is it A. Full protection against all liens, B. No protection against liens that existed before the seller owned the property, or D. Protection if the seller was aware of the lien? The correct answer is B. No protection against liens that existed before the seller owned the property. A bargain and sale deed implies ownership but provides no warranties against title defects or liens, so Tom has no protection from pre-existing liens under this deed. Sarah receives a property from her uncle through a deed that contains no warranties or guarantees about the title. What type of deed did Sarah most likely receive? Is it A. General warranty deed, B. Special warranty deed, C. Quitclaim deed, or D. Bargain and sale deed? The correct answer is C. Quitclaim deed. This scenario describes a quitclaim deed which transfers any interest the grantor may have in the property without any warranties or guarantees about the title. Title insurance and title evidence. Which document is most commonly used to provide evidence of marketable title in a real estate transaction? Is it A. Deed of trust, B. Promissory note, C. Title insurance policy, or D. Property tax bill? The correct answer is C. Title insurance policy. A title insurance policy is the most common form of evidence of marketable title, as it protects both the buyer and lender against defects in the title that may not be discovered through a standard title search. Which of the following is not typically covered by a standard title insurance policy? Is it A. Undisclosed heirs, B. Zoning ordinance changes after purchase, C. Forgery in the chain of title, or D. Errors in public records? The correct answer is B. Zoning ordinance changes after purchase. Why this can be tricky. Standard title insurance policies cover past defects, such as forged documents or undisclosed heirs, but do not cover issues like zoning changes or government regulations that arise after the policy is issued. Maria purchases a home and later discovers an unpaid lien from the previous owner. Which type of title evidence would most likely protect her against this loss? Is it A. Title insurance policy, B. Warranty deed, C. Quitclaim deed, or D. Survey map? The correct answer is A. Title insurance policy. A title insurance policy protects new owners like Maria from financial loss due to defects such as undisclosed liens that existed before she took ownership, provided the issue was not excluded from coverage. If a buyer receives a quitclaim deed, which of the following statements is most accurate regarding the transfer of title? Is it A. The buyer is guaranteed a clear title, B. The seller warrants that the title is free of defects, C. The buyer receives title insurance automatically, or D. The seller transfers any interest they have without warranties? The correct answer is D. The seller transfers any interest they have without warranties. Why this is tricky. A quitclaim deed transfers only whatever interest the grantor has, if any, and offers no warranties about the title's validity or freedom from defects. After closing on a property, John discovers that a neighbor claims part of his land due to an old recorded easement. What should John have reviewed to identify this issue before purchase? Is it A, property appraisal, B, title search, C, home inspection report, or D, mortgage loan estimate? The correct answer is B, title search. A title search would have revealed recorded easements affecting the property, allowing John to address the issue before closing. Title insurance may cover losses, but the search itself identifies such encumbrances. Recording acts and priority of interests. Which type of deed provides the greatest protection to a buyer regarding title defects? Is it A, quitclaim deed, B, special warranty deed, C, general warranty deed, or D, bargain and sale deed? The correct answer is C, general warranty deed. A general warranty deed offers the most comprehensive protection because the grantor guarantees clear title against all claims, both past and present. Other deeds, such as special warranty or quitclaim, provide less protection to the buyer. Under a Notice Recording Act, who has priority if a subsequent purchaser records before the original grantee but has actual notice of the prior deed? Is it A, the subsequent purchaser has priority, B, the original grantee has priority, C, both parties share equal priority, or D, the party who records first always has priority? The correct answer is B, the original grantee has priority. Why this can be tricky? Under a Notice Recording Act, a subsequent purchaser who has actual notice of a prior unrecorded deed cannot claim priority, even if they record first. Actual notice defeats their claim, regardless of recording order. Which of the following statements about recording acts is not correct? Is it A, recording acts are designed to protect subsequent purchasers, B, a bona fide purchaser must give value and lack notice of prior claims, or D, all recording acts protect those with actual notice of prior interests? The correct answer is D, all recording acts protect those with actual notice of prior interests. Why this is tricky? The statement that all recording acts protect those with actual notice is false. Only bona fide purchasers without notice are protected. The other statements are generally correct regarding the purpose and function of recording acts. Maria buys a property from Tom, but Tom had already sold it to Lisa, who did not record her deed. Maria records her deed first and has no knowledge of Lisa's purchase. Who owns the property under a race notice statute? Is it A, Maria, B, Lisa, C, Tom, or D, ownership is split between Maria and Lisa? The correct answer is A, Maria. Under a race notice statute, Maria prevails because she was a bona fide purchaser without notice and recorded her deed before Lisa. Both elements, lack of notice and first to record, are required for priority. A lender records a mortgage on a property, but a mechanic's lien for unpaid work is later filed and relates back to work started before the mortgage was recorded. Who has priority if the property is foreclosed? Is it A, the lender, B, the property owner, the mechanic's lien holder, or D, priority is determined by who files first, regardless of work start date? The correct answer is C, the mechanic's lien holder. Mechanic's liens often have priority over mortgages if the work began before the mortgage was recorded, because the lien's priority can relate back to the start of the work, not the recording date. Clouds on title and title defects. What is a cloud on title in real estate terminology? Is it A, an unresolved claim or encumbrance affecting ownership rights, B, a type of insurance policy for homeowners, C, a government-issued certificate of title, Or D, a document used to transfer property ownership. The correct answer is A, an unresolved claim or encumbrance affecting ownership rights. A cloud on title refers to any claim, lien, or encumbrance that may impair the title to real property, making it unclear or questionable. Clearing such clouds is essential before transferring ownership to ensure marketable title. Which of the following would not be considered a title defect when selling a property? Is it A, unpaid property taxes? B, a mortgage lien that was properly released years ago? C, a forged deed in the chain of title? Or D, an undisclosed heir with a possible ownership claim? The correct answer is B, a mortgage lien that was properly released years ago. Why this can be tricky? Not all issues are title defects. An expired mortgage lien no longer affects title, while unpaid taxes, forged deeds, and undisclosed heirs can all create defects that must be resolved before transfer. Maria is preparing to sell her home, but discovers that a previous owner's unpaid contractor has filed a mechanic's lien. What must Maria do before closing the sale? Is it A, ignore the lien and proceed with the sale? B, transfer the lien to the buyer after closing? C, pay off or otherwise clear the lien before closing? Or D, ask the contractor to wait until after the sale to be paid? The correct answer is C, pay off or otherwise clear the lien before closing. Maria must resolve the mechanic's lien before closing, as it is a cloud on title. The property cannot be transferred with clear title until the lien is satisfied or removed. During a title search for a commercial property, the title company finds a recorded easement that was never disclosed to the current owner. How does this affect the transfer of ownership? Is it A, it has no effect on the transfer process? B, it automatically cancels the sale contract? C, it only affects the buyer's financing options? Or D, it creates a cloud on title that must be resolved or disclosed? The correct answer is D. It creates a cloud on title that must be resolved or disclosed. An undisclosed easement is a title defect that must be addressed. It may limit the owner's rights and affect the property's value, so it must be disclosed and resolved before transfer.
Did you get a different answer? Or maybe you have a question about the exam in general? Drop it in the comments below. We read and answer them personally.
Legal descriptions and property rights. Methods of legal description. Which method of legal description uses distances and directions to define the boundaries of a property? Is it A, lot and block system? B, meets and bounds method? C, government survey system? Or D, rectangular survey method? The correct answer is B, meets and bounds method. The meets and bounds method describes property boundaries using measurements of distance and compass directions, making it one of the oldest and most detailed legal description methods. Which legal description method is least likely to be used for describing a property in a densely populated urban subdivision? Is it A, lot and block system? B, government survey system? C, meets and bounds method? Or D, recorded plat system? The correct answer is C, meets and bounds method. Why this can be tricky? Urban subdivisions often use the lot and block system, while the meets and bounds method is more common in rural or irregularly shaped parcels, making it least likely in urban subdivisions. Maria is reviewing a property deed that describes the land as the northwest quarter of Section 10, Township 3 North, Range 2 East. Which method of legal description is being used in this deed? Is it A, government survey system? B, meets and bounds method? Or D, street address method? The correct answer is A, government survey system. This description uses the government survey system, which divides land into sections, townships, and ranges for precise identification, especially in states that adopted the public land survey system. What is the primary purpose of a legal description in a real estate transaction? Is it A, to provide the property's mailing address, B, to list the previous owners of the property, C, to describe the improvements on the property, or D, to uniquely identify the property being conveyed? The correct answer is D, to uniquely identify the property being conveyed. A legal description uniquely identifies the exact boundaries and location of a property, ensuring there is no confusion or dispute about what is being transferred in a transaction. A developer files a subdivision plat map with the county, assigning numbers to each lot and block. What method of legal description will be used for deeds in this subdivision? Is it A, meets and bounds method, B, government survey system, C, lot and block system, or D, street address method? The correct answer is C, lot and block system. The lot and block system is used when a subdivision plat is recorded, allowing properties to be described by lot and block numbers within the recorded map. A surveyor is hired to describe a rural property and uses compass bearings and measured distances from a starting point to outline the land. Which method of legal description is the surveyor using? Is it A, lot and block, B, rectangular survey system, C, meets and bounds, or the correct answer is C, mets and bounds? This scenario describes the meets and bounds method, which relies on physical measurements and directions to define property boundaries, commonly used for irregularly shaped parcels or rural land. Riparian, littoral, and water rights terminology. Which term refers specifically to the rights of a property owner whose land borders a river or stream? Is it A, riparian rights, B, littoral rights, C, easement rights, or D, mineral rights? The correct answer is A, riparian rights. Riparian rights are the legal rights of landowners whose property borders a natural watercourse, such as a river or stream. These rights allow reasonable use of the water, provided it does not harm upstream or downstream owners. Which of the following statements about littoral rights is not accurate? Is it A, littoral rights apply to properties bordering oceans, B, owners with littoral rights may have access to the water's edge, C, littoral rights apply to properties bordering rivers, or D, littoral rights are subject to government regulation? The correct answer is C, littoral rights apply to properties bordering rivers. Why this is tricky? The distractors are plausible, but only one statement is incorrect. Littoral rights do not apply to properties bordering rivers or streams. They apply to properties adjacent to large, stationary bodies of water, like lakes or oceans. If a property owner claims exclusive rights to all water flowing past their land, which legal principle are they misunderstanding? Is it A, they are correctly applying riparian rights, B, they are misunderstanding the limits of riparian rights, C, they are exercising their mineral rights, or D, they are following the doctrine of accretion? The correct answer is B, they are misunderstanding the limits of riparian rights. Why this can be tricky? The question tests knowledge of water rights limitations. Riparian rights allow reasonable use, not exclusive control. The doctrine of prior appropriation or absolute ownership does not apply in most riparian jurisdictions. Maria owns a home on the shore of a large lake and wants to build a dock extending into the water. Which type of water rights will determine her ability to do so? Is it A, riparian rights, B, easement rights, C, littoral rights, Or D. Air rights. The correct answer is C. Literal rights. Maria's property borders a stationary body of water, so literal rights apply. These rights govern the use and enjoyment of land bordering lakes and oceans, including building docks, subject to regulations. A developer purchases land along a river and plans to divert water for irrigation. What legal doctrine typically limits how much water the developer can use? Is it A. Literal doctrine, B. Riparian doctrine, C. Eminent domain, or D. Adverse possession? The correct answer is B. Riparian doctrine. The riparian doctrine limits water use to reasonable amounts for land bordering the watercourse. The developer cannot divert unlimited water, as this would infringe on the rights of other riparian owners. Air rights, subsurface rights, and surface rights. Which right allows a property owner to extract minerals such as oil or gas from beneath their land? Is it A, B, surface rights, C, subsurface rights, or D, water rights? The correct answer is C, subsurface rights. Subsurface rights grant the property owner the authority to access and extract minerals, oil, or gas located below the surface of the land. These rights can be sold or leased separately from surface rights. Which of the following is not typically included when someone purchases the surface rights to a property? Is it A, the right to build a house on the land, B, the right to extract oil from beneath the land, C, the right to plant a garden on the property, or D, the right to walk across the property? The correct answer is B, the right to extract oil from beneath the land. Why this can be tricky? Surface rights only cover the use of the land's surface. Air rights and subsurface rights can be owned or transferred separately. So purchasing surface rights does not automatically include subsurface rights. If a property owner sells their air rights, which of the following can they still do? Is it A, construct a high-rise building above the property, B, prevent airplanes from flying over the property, C, extract minerals from beneath the property, or D, plant crops on the land's surface? The correct answer is D, plant crops on the land's surface. Why this is tricky? Selling air rights removes the ability to build upward, but the owner retains surface and subsurface rights, so they can still use the land surface for activities like farming or gardening. Maria owns a downtown building and sells the air rights above it to a developer who plans to build a tower. What does Maria still retain after the sale? Is it A, the right to build upward above her building, B, the right to use the building as it currently exists, C, ownership of the airspace above her building, or D, the right to restrict all future construction on the property? The correct answer is B, the right to use the building as it currently exists. Maria retains the surface rights to her building and the subsurface rights unless she sells those separately. She no longer controls the space above her property that she sold as air rights. A landowner leases subsurface rights to a mining company but keeps all other rights. What can the mining company legally do under this lease? Is it A, build a shopping mall on the surface, B, construct a rooftop garden above the property, C, extract minerals from beneath the land, or D, sell the land to another party? The correct answer is C, extract minerals from beneath the land. The mining company can access and extract minerals from beneath the land, but cannot use the surface for unrelated purposes or claim air rights unless specified in the lease. Fixtures and trade fixtures distinctions. Which of the following best defines a trade fixture in real estate law? Is it A, a permanent improvement made by a property owner? B, an item installed by a tenant for business use that can be removed at lease end? C, a fixture attached to land by the landlord for residential use? Or D, a structure built on leased land by the property owner? The correct answer is B, an item installed by a tenant for business use that can be removed at lease end. A trade fixture is an item installed by a tenant for business purposes and is typically removable by the tenant before the lease ends. Unlike regular fixtures, trade fixtures remain personal property of the tenant. Which item would most likely be considered a fixture rather than a trade fixture when a tenant vacates a leased retail space? Is it A, movable display racks? B, removable shelving units? C, built-in lighting? Or D, cash registers? The correct answer is C, built-in lighting. Why this can be tricky? Built-in lighting is typically considered a fixture because it is permanently attached and not specific to the tenant's business, unlike display racks or shelving, which are usually trade fixtures. Which statement about fixtures and trade fixtures is not accurate? Is it A, fixtures are usually considered part of the real property? B, trade fixtures are installed by tenants for business purposes? C, fixtures are transferred with the sale of the property unless otherwise agreed? Or D, trade fixtures always remain with the property after the lease ends? The correct answer is D, trade fixtures always remain with the property after the lease ends. Why this is tricky? Trade fixtures are generally removed by the tenant before lease end. If left behind, they may become the landlord's property. The statement that trade fixtures always remain with the property is incorrect. Maria leases a storefront and installs custom bakery ovens. When her lease ends, can she legally remove the ovens before vacating? Is it A, yes, because the ovens are trade fixtures installed for her business? B, no, because all fixtures must remain with the property? C, yes, but only if the landlord gives written permission? Or D, no, because the ovens are now part of the real property? The correct answer is A, yes, because the ovens are trade fixtures installed for her business. Custom bakery ovens installed by Maria for her business are considered trade fixtures, so she can legally remove them before the lease ends, provided she repairs any damage caused by removal. A tenant in a commercial office installs cubicle partitions and leaves them behind after the lease expires. Who now owns the partitions? Is it A, the tenant, because trade fixtures always remain personal property? B, the landlord, because abandoned trade fixtures become part of the real property? C, the manufacturer, since the partitions were leased? Or D, the next tenant, as they now occupy the space? The correct answer is B, the landlord, because abandoned trade fixtures become part of the real property. Cubicle partitions are trade fixtures, but if the tenant leaves them after the lease ends, they typically become the property of the landlord through a process called accession. Emblements and crops classification. Which term describes annual crops that are considered personal property even though they are attached to the land? Is it A, emblements, B, fixtures, or D, trade fixtures? The correct answer is A, emblements. Emblements are annual crops cultivated by a tenant, considered personal property, and can be removed by the tenant even after the lease ends, as long as the crops were planted before the lease termination. Which of the following is not typically classified as an emblement under property law? Is it A, wheat, B, corn, C, apple trees, or D, soybeans? The correct answer is C. Apple trees. Why this can be tricky. Perennial crops like apple trees are not emblements because they do not require annual planting. Only annual crops grown for harvest each season are considered emblements. Maria, a tenant farmer, planted soybeans in the spring, but her lease was unexpectedly terminated in the summer. Can she legally harvest the soybeans she planted? Is it A. No, the crops belong to the landowner. B. Yes, because emblements are her personal property. C. Only if the lease stated she could. Or D. No, unless she pays the landowner. The correct answer is B. Yes, because emblements are her personal property. Maria can harvest the soybeans because emblements are considered her personal property, allowing her to reap crops she planted before the lease ended, even if the lease was terminated unexpectedly. A landlord sells a property in July after the tenant has planted and tended to a crop of corn. Who has the right to harvest the corn in the fall? B. The landlord who sold the property. C. Both the tenant and the new owner share the crops. Or D. The tenant who planted the corn. The correct answer is D. The tenant who planted the corn. The tenant retains the right to harvest the corn because emblements protect tenants' interests in annual crops they have planted and cared for, even if the property is sold before harvest.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsey.ai to start your free trial of Birdsey, your AI-powered study partner.